Welcome, everybody, and thank you for your attendance, particularly those who have to testify and answer questions for us, because I know you put in a lot of extra work to be ready for it. This hearing is on the oversight of a bill that has a long name called Ensuring Patient Access and Effective Drug Enforcement Act. Now, somebody's going to have a pronunciation for that acronym, but I'm not going to. I'm going to refer to it as the law or the bill. And I'm eager to hear from all of our witnesses today. Some would like to see this law repealed. Others insist that it should remain in place. I haven't made my mind up on that issue, so I'm interested in hearing both sides of the argument. This discussion is particularly important given the continuing opioid epidemic that has ravaged this country through the past several years. I do have concerns with how we got to where we are today and the discussions that we're having today. When Congress took this bill up in 2015 and 2016, there was little to no fanfare about the proposal. The basic goal of the bill seemed very modest: provide a definition for the term imminent danger. Distributors and other providers would have more clear guidance for what was required of them before DEA could issue an immediate suspension order called ISO. In this industry, an ISO can be a death sentence. From their standpoint, the clarification seemed not only fair, but a necessary step in helping figure out how to comply with the law. There was another practical concern, that of ordinary patients with legitimate needs having access or losing access to essential prescriptions if legitimate distributors were shut down. DEA understandably had some concerns about curbing their enforcement powers, but the unlimited, undefined enforcement authority needed some refinement. DEA also had litigation risk with such undefined authority. So DEA too had an interest in working towards amending the language to reduce their own risk. My understanding was that DEA provided technical assistance to both House and Senate staff for other members who were responsible for drafting the bill. In fact, DEA admitted as much in testimony before the House of Representatives October of this year. When the bill came to the Senate, it was referred to this committee. I took up the bill based in part on assurances from DEA and the Department of Justice that they agreed to the language in the final bill. We discharged the bill from committee, and we did that by unanimous vote. The bill then passed the Senate by unanimous consent. It also passed the House by unanimous consent. President Obama signed the bill into law April 2016. DEA testified that they advised President Obama to do just that. So let me be clear. If DEA or Department of Justice didn't want this bill, I wouldn't have taken it up, period. Then the Washington Post and 60 Minutes ran pieces criticizing the new law. Both stories highlighted former DEA employees and quoted a law review article from the acting chief administrative law judge for DEA. The reports in the media suggest that Congress was in the back pocket of the opioid industry and that this bill was a giveaway to the prescription drug industry. So as I've described, it should be fair to everybody to see, fairly clear to everybody to see, that nothing could be further from the truth. I've worked hard my entire career trying to combat illegal drug trafficking. My friend here from California and I have worked together on a group called the Drug Caucus to do just that, besides the work we do in this committee. And we did it to provide more effective ways for law enforcement to do their job in the drug enforcement area. I'm especially frustrated by the DEA itself, which gave Congress the go-ahead to enact this legislation. We wouldn't be here today if the DEA told us that they objected. The news reports also suggest that the law effectively stripped DEA of its enforcement power. The data appears to show otherwise. In other words, the data shows this: prior to the passage of the bill, between the years 2011 and 2015, the amount of immediate suspension orders dramatically decreased. Since the law was passed, the amount of immediate suspension orders has increased. Moreover, the number of opiates distributed overall decreased between 2016 and 2017, which all comes after passage of the bill. DEA has said that the law, quote, did not stop DEA from doing its job in the diversion space, end of quote. Even though this bill was vetted by Congress once, we all have to be open, at least I'm open, to re-examining the criticisms of the law. Hence, we're here, and I'm looking forward to the hearing what those are. In other words, what the criticisms of the law are. But we shouldn't be repealing laws just because the loudest person in the room and solely based on one person's say-so. The DEA agent who was the centerpiece of the news article is a consultant for trial lawyers who are suing the industry. So his objectivity could be questioned. The sensational news stories failed to question this conflict of interest. I look forward to hearing the testimony from the witnesses and finding new ways to strengthen our law enforcement efforts without preventing legitimate access to medications that real patients with real legal prescriptions need. Opioids continue to be a huge problem in this country. It is vital that our federal laws keep up with the best way to combat illegal opioid use.